5 seconds to go. Start. Section. The rent authority may order the defense against eviction to be struck out and proceed with the hearing of the application. Section 29. Recovery of possession for occupation and re-entry, where a landlord recovers possession of any premises from the tenant in pursuance of an order made under clause Q of subsection 2 of section 20 or under sections 21, 22, 23, 24 or 31, the landlord shall not, except with the permission of the rent authority obtained in the form specified in Schedule 9 to this Act, re-let the whole or any part of the premises within 3 years from the date of obtaining such possession, and in granting such permission, the rent authority may direct the landlord to put such evicted tenant in possession of the premises, provided that where a landlord recovers possession or any premises from the tenant in pursuance of an order made under clause Q or subsection 2 of section 20 for occupation after reconstruction or rebuilding, the period of 3 years shall be reckoned from the date of completion of reconstruction or rebuilding as the case may be. Section 38. Procedure to be followed by rent authority. No order which prejudicially affects any person shall be made by the rent authority under this Act without giving him a reasonable opportunity of showing cause against the order proposed to be made and until his objections, if any, and any evidence he may produce in support of the same have been considered by the rent authority, subject to any rule made under this Act and other provisions of this Act. The rent authority shall, while holding an inquiry in any proceeding before him, follow as far as may be the practice and procedure of a court of small causes, including the recording of evidence. The rent authority shall not ordinarily allow more than 3 adjournments at the request of a party throughout the proceedings, and in case he decides to do so, he shall inform the chairman the reasons therefor and order to pay the other party the reasonable cost. The rent authority shall issue summons in relation to every application under this Act in the form specified in Schedule 3 to this Act. The rent authority shall, in addition to and simultaneously with the issue of summons for service on the opposite party, also direct the summons to be served by registered post, acknowledgement due under certificate of posting addressed to the opposite party or his agent authorized to accept the service at the place where the opposite party or his agent actually and voluntarily resides or carries on business or personally works for gain, and shall also direct affixing of the same on the door of the premises in dispute and get a munadi in this behalf. This shall constitute valid service of summons. An application under section 19 for cutting off essential service shall be dealt with in accordance with the procedure specified in this subsection. Stop.